Hello, everyone. Very good evening, and we welcome you to our into our session on business English series. Today is our webinar number 3, and this is the webinar dedicated to entity choice, to incorporation, and to Delaware law. So it's extremely important and very interesting topic, and we are excited that we have with us our virtual English specialist, Alexandra Dolce, an attorney from New York, who is going to do this webinar. As usual, speaking about the logistics, our webinar will last for 1 hour and a half from 7:30 now until 9 o'clock p.m. Moscow time. So Alexandra will be giving us giving us the presentation. There will be slides, and you are very welcome to ask questions. In order to ask questions, you need to be subscribed to our YouTube channel, and you can write in comments. Also, today we will try a new feature. We were fighting with this feature with Alexandra a lot with technology. So usually when Alexandra asks the questions or gives you some situations, you give your answers in YouTube comments. Today we will try with you a polling system. So at some moment there will be some instructions for you. You will need to take your phone to go onto a special website, and you will be able to vote there. But there is always a but. There is a disclaimer. We hope this technology works. If it doesn't work, which might happen, we will be just continuing voting on YouTube in comments. So we'll see how it goes. All right. So we are very hopeful, but we'll see. So Alexandra, the floor is yours.
Okay, great. Good evening, Russia. Again, I have my hard copy of my slides next to me. Sometimes I can't see the screen thoroughly because the font is too large. So I might refer to my slides. So if you see me here paper or you see me looking the other way, I'm referring to the hard copy of my slides. That's one. Sophia talked about the disclaimer. So we're hoping that the polls work. And again, you may hear Sophia say, Alexandra, hands. I have a tendency to talk with my hands. So if she's saying that, that means my hands are in the way. That being said, let us start. So welcome. We're going to be doing business entities, sole proprietor, partnership, and corporation in that order. Okay. Oh, so sole proprietorship, it's owned and run by one person in which there is no legal distinction between the owner and the business entity. That's very, very important, because when we go down the line, we're going to see that there can be a distinction between the person and the business entity, but as a sole proprietor, there is no distinction. You are your business is you. So I'm going to be talking about New York law, and I'm also going to be talking about Delaware law today. New York for the sole proprietorship and partnership, I believe, and for the corporations, Delaware law, because a lot of corporations incorporate in Delaware, and we'll soon find out why. So how to set up a sole proprietorship in New York, okay? You choose a business name. You can use your legal name or fictitious name. So you can, it could be Alexandra Dolce, doing business as, or DBA, the Champagne Queen, okay? So avoid using a name that is already in use and a name that can get you in trouble for trademark infringement. You don't know how many people that I know, they choose a name, they don't, check to make sure someone else is using the name, and they're going to do a conference. They start the conference, they start advertising, they print paper and everything for the conference. When somebody they get a letter and telling them you can't use this name. So be very, very careful. Okay. So number 2, when you get your name, you file the assumed name with the county. If your business name is different from your legal name, New York requires you to register your business with your business name with the county clerk of each county where you do business. For instance, I live in Manhattan. I would file my business name with the New York County's clerk's office. However, if I was going to do business both in Manhattan and Brooklyn, I would have to file it there, or Long Island, or wherever. So wherever you're going to do business, you have to file your assumed name.
Mm-hmm. So can I ask a question? So it's
Sure.
like different applications, or multiple applications, not only one?
No, it's different applications. So the
Mm-hmm.
New York County one may be totally different from the Brooklyn County one.
Okay.
Yeah, so it's different applications. Yeah. So wherever you're going to do business, you do. Yeah. Okay. Zoning and permits and clearance. So business license permit. Business licenses are permits issued by government agencies that allow individuals or company to conduct business within the government's geographical jurisdiction. So you have to have that. And you have to have that because you have to know the zoning, you have to know, what you can do, what you can't do, etc., where you can do it. So it's very, very important. Zoning clearance. So clearance means an administrative review conducted by planning staff to certify that an existing or proposed use or development on a property conforms with zoning ordinance. For example, if an area is zoned for residential property only, no commercial property or activity should be allowed. I can't open my champagne store because I don't have zoning clearance. The area is for residences only. So, and the reason why this is important, the zoning is continued because it's different in each county. So say, for instance, a champagne store can't be opened in a residential area in Manhattan. Maybe in Brooklyn, where I intend to do business, I can open it in a residential area. So that's why zoning is very, very, very important. For instance, in Texas, there's a Houston, Texas, and some places in Houston, Texas, you may have a beautiful residential area, but there are no zoning laws. So in your beautiful residential area, I could put a nightclub and say open until 2, 3 o'clock in the morning, and that won't be a violation. So zoning is very important. All right. So I'm interested in opening a bakery. I live in a wonderful residential neighborhood. And all my neighbors love my cookies, cupcakes, and pies. I decided to go into business as a sole proprietor. I started baking goods and selling them in my garage. What may be the consequence of working out of my home?
Okay, so we have a hypothetical or abstract theoretical situation, everyone. So, and we will invite you to write your comments on YouTube. So, and if speaking about while we are waiting for the answers and we give our participants some time to digest and understand all of the conditions of the situation or hypo. The question is, so in Russia, we don't usually use the expression sole proprietor. We would usually say literally individual entrepreneur, or in UK, they would say sole trader. So in the United States, it's only sole proprietor. So if you say individual entrepreneur, you might not be understood, or it is okay. Oh. So, Alexandra, is it okay, or it's only sole proprietor is in use?
It's only sole proprietor. We use sole proprietor. I own my business. I'm a sole proprietor. That's it.
Yeah. Okay. So, and we do have some questions, and I'm very grateful for those who are answering. So there are different options. So Marusia says a fine might be. So Vladislav, I think he agrees with it. Then there may be some fire hazard, Tamara says. Antonina is more direct. She says it might be a fine or a jail even. So, and maybe the litigation. Also, Daria says you need to register your business first, then check the zoning clearances. So Daria has been listening to you, Alexandra.
All of them. So all of them are correct. So what may be the consequences? They may fine me, and they'll probably have me closed down if it's not zoned for starting a bakery. So I'm definitely going to get a fine. That's definite. I'm definitely going to get a fine, but they're probably going to request that I close down. Now, in some neighborhoods, like outside of New York City, like Philadelphia, you can walk to a neighborhood and you see people selling cookies, ice cream, and food, and it's a residential neighborhood. So there are no consequences for zoning issues. So you have to know the laws of where you're going to open the business. Okay, number 4, you have to obtain an EIN. If you plan to have employees, you need an EIN. An EIN is a 9-digit number issued by the U.S. Internal Revenue Service, IRS, for tax reporting purposes. You don't need an EIN if you plan to have no employees, because you can use your personal social security number. However, some banks require that you have an EIN in order to open a banking account. So EIN, I would recommend everyone have an EIN, because that distinguishes you from your regular social security number. You don't like your social security numbers are very, very private things in the US. So you don't want everyone having access to it. Okay, so we have a poll. Okay. Let's see if this works.
Mhm.
It doesn't seem to.
Okay, yeah.
Okay.
So let me see. Oh, that's already the result slide.
Oh,
So
let's see. Okay, let's see. No.
yeah, so you need to open up a poll.
Okay. No, this is not. Ooh. Okay, question slide. No. Yep.
Mhm.
It's not putting the number. It's not, yeah. It has the ID number, but it's not.
Yes, so it's again. So as you can see, we're fighting with some technology here.
Yeah, so it works sometimes,
Okay.
it doesn't. Okay, so I guess the question.
Then let's
Go ahead.
answer the question in YouTube, because it does show us everything, but we need to press the button somewhere to open the poll, and where it happens.
No. Mm-mm.
No.
It's
Yeah,
the-
and I try to access. Okay, everyone. So our participants, our dearest participants. So then let us try to answer the question in YouTube. So you can see we have a question here. What is the most important when starting as a sole proprietor, which will be a synonym to individual and entrepreneur? So, and you can say, you can either answer in full, or you can write 1, 2, or 3. And then we'll see the numbers. We were trying to make it more visual. Alexandra has been working on it for a week or longer. Well, actually more than a month, I would say, but
Yeah.
Vivox doesn't like us. Yes.
Okay, no.
Oh, no, let's go back. So,
Yeah.
and then we will try to see, so what is the most important when starting a sole proprietorship? Applying for EIN, filing your assumed name within the county, applying for licenses or permits. So what do you think? You may say 1, 2, or 3, or write it in full. And then, Alexandra, I will just tell you the answers, okay? So I suspect, Alexandra, that by the end of our series, we'll nail it.
I'm not going to hold my breath at this point. Really, I mean, it has the ID and everything. It's just, I don't know if it's.
I know. It's just, it's just being so not nice to us. Okay, so anyway, we have quite a lot of answers. So, and a lot of our viewers vote for number 3, applying for licenses, permits. Someone says filing your name, filing your assumed name within the county. And Natalia says that actually all 3. She likes all of them.
The most important thing is applying for licenses and permits, because you have to know where you can work and how you can do it. You know what I mean? You could always apply for EIN. You could always file your name. But, let's say you apply for EIN, you filed your assumed name, and you want to work in Manhattan, and you find out that you can't get a permit or a license for Manhattan. So you have to apply for your license first. That's the most important.
Okay. Thank you very much. So those of you who voted for the 3rd one, you are absolutely right. Thank you very much. Okay. So then let's get moving, and everyone. So we will be just dealing with you with our voting via YouTube.
Okay, the benefits of having a sole proprietorship: easy to set up and low cost. So it's very low cost to set up. You go, you get your license, you file your name, and that's it. No corporate or business taxes, no annual reports or filings. You don't have to do an annual report. You're not restricted by formal business structure, and easy record keeping. So it's only you and maybe 2 or 3 people. So it's not major. You don't have to, manage a lot of records. It's 1, 2, 3. Disadvantages of sole proprietor is major one: unlimited personal liability. You're not separate from your company. If your business is sued, your assets, your car, your home, your bank account are vulnerable. So say, for instance, I own the champagne shop, and for some reason, someone comes into my shop and they slip and fall and they hurt themselves, and I'm found liable to them. They can get my car, my home, my bank account to pay that debt off. So I am not separate from the company. Another disadvantage is you must pay self-employment tax on all earnings. Okay. It's difficult to raise money. You're by yourself. So say, for instance, you need $100,000 and you only have $8,000, people are going to be like, oh, you're by yourself. Well, wait, we'll see what happens. If you're a group, people are more apt to give you money. Inability to take on business debt, hard to get loans because you're small, you don't have shareholders, etc. People don't like to give loans to companies that are very, very small, or companies that don't have that much money or equity.
Mm-hmm. And there is a question, from one of our viewers. And how much is this self-employment tax?
It depends. You know what I mean?
But,
it depends. It's probably based on regular income tax. So that changes from year to year. It's usually, if it's regular income tax, it's usually about maybe totally and this is in New York, because in New York we pay federal tax, state tax, and a local tax. So it's probably 1/3 of how much you make.
Yes, that's big. Okay.
Okay, we have another question. This is okay. What's a major disadvantage of having a sole proprietorship?
So, and it's a question to our participants.
The
major one. So you can read, you can see the options. Again, you may go for 1, 2, 3, because you obviously can see the first one, banks are not always willing to lend you money. There is unlimited personal liability, or it's difficult to find the employees. Okay, and what is interesting, so mostly we have quite a lot of our viewers, and we're very grateful that you are such active participants. Thank you so very much, Timur, Vladislav, Marusia, Olga, Daria, and Pavel, Tamara. So everyone goes for the second one. So
yeah, unlimited personality, that's the major one. You know what I mean? You run your business, it's great, it's small, but if something happens, you're the one that's in trouble. So that's why you should always keep up in the United States. I tell people, if you're having a sole proprietorship, make sure you have insurance. Make sure you have insurance in case you have employees, because a lot of times employees sue you. Make sure you have insurance for your premises. If something happens, slip and fall. So make sure your insurance is up to par, because if it's not, you will lose everything. A partnership. So partnerships are very interesting and very important, and very common in the United States. A partnership is 2 or more persons that carry on as co-owners in a business for profit. Remember that, very important. The intention of the parties to carry on as partners must be expressed in an agreement. Okay, where there is no agreement, you have an implied partnership. Okay, very, very important. An implied partnership, when there is no enforceable or express partnership agreement, the party seeking to establish an implied partnership must show that a partnership nevertheless existed based on the conduct, intention, and relationship between the parties. And I'm going to give you a hypo based on this coming up. Okay. What court looks at to see if one exists, to see if an implied partnership exists: sharing profits, sharing of losses, ownership of partnership assets, joint management control, joint liability to creditors, intention of the parties, compensation, contribution of capital, loans to the organization. Okay. So I go to court and I said, I'm an implied partner. We worked as partners, and the court is going to say, okay, did you share profits? Did you share losses? How are these things? How were you compensated? What were your intentions? He's going to ask both of us, what were your intentions? How did you know that was, your partner's intentions? Joint liability to creditors. You know what I mean? Are we applying for credit separately? All of these things are looked at in order to determine if there was an implied partnership or not. Okay, so this is a hypo. Michael and Lee are best friends. They decide to go into business as partners, but there is nothing in writing. For the first 6 months, they share all profits and responsibilities. After 6 months, Lee decides that he's too busy to help Michael run the business, so he cuts back on his responsibilities. At the end of the month, he goes to Michael to collect his share of the profits. The profits for the month are $5,000. Michael gives Lee $1,500. If Lee sues Michael for the remaining $1,000, will he win? Why or why not?
Oh, that's a hard one. I say it's a hard one. So while we're waiting for the answers, because in Russia, we very rarely, we do have a partnership our viewers may correct me if I'm wrong, which is like exists in the paper, but it's very rarely that the partnership is actually used as a form of business to do business in Russia. That's why it might be a difficult one. So
you just said something though. You said it's on paper, but if it's on paper, why is it not used? That's what I don't get.
That's Russia. First,
yes. Okay.
And secondly, yes, it's like it's the state gives you this opportunity to business to conduct it, but in practice, people just realize that it's not that maybe convenient to do business. So very rarely you actually see that someone does business, is doing business in a partnership. So it may be like not on paper. So, but the form of a business may be different. So, and so on. So you might have like someone is a sole proprietor, but actually in reality, he or she may have a partner who is not on paper. And that is very difficult to prove then in reality. If something goes wrong, if the relationship becomes sour and so on and so forth. So this is much more difficult situation, as I can see.
Yeah.
So
that's why they're implied partner, because they don't want somebody to be, to have the advantage. So if the judge is going to look at how long did you share profits? Did you share losses? How much money did you give? Were you there every day? You know what I mean? Who owes the debts? All of these things. That's what they use to determine if there was an implied partnership. You know what I mean?
And I suspect it is a very problematic situation when, for example, there was a husband and wife and they were doing business together. And then one of them says we had an implied partnership. How to distinguish that was like the family or that was a partner? So it might be also a difficult thing.
Hold on. The judge is going to do this. Did you share profits? Did you share losses? Ownership of who owned the assets? Joint management of control? Joint liability to credit? Intention of the parties? What was your intention? What did you get compensated? How were you compensated? Who contributed, etc. So they're going to look at that.
Okay.
Right, so
and now let's the answers. So Pavel says yes. Marusia says yes, unless they terminated the initial agreement. Tamara says yes. Olga, I assume yes, because you share profits and liabilities in half. Daria says the share of profits was not agreed in writing, so probably not. Depends on the court decision. Yuri says if he can prove it, then yes. Timur says definitely he will win, even if it's not on paper. They conducted their business in partnership. Irina says only if he can prove that during the last part of the year he had the same responsibilities as a partner. And Pavel says no, because there are no any documents in writing. As you can see, a lot of options.
There are a lot of options. The basic thing is, what the court is going to do, the court is going to go back, as we said, and the court is going to look at all these things, So, they shared profits for a couple of months. Did they share losses? Who was, carrying the losses? Did they share responsibilities? How long did they share responsibilities? What was the intention? He's going to talk. What was your intention? You decided to go into business, but did you decide to be partners? How much money did you give? Did you give 50% of the money? Did you give a third of the money? So they're going to look at a lot of things, and they're going to make a determination if there was an implied partnership. Based on this alone, I would say no, there isn't. The first 6 months, they share all profits and responsibilities. After that, he decides he's too busy. Which means, if you're an actual partner, you're going to be involved in the business. You're going to be involved in the day-to-day activities of the business. So based on that, I would say the court would not find an implied partnership.
For the last month or for the whole, or like the whole?
I would say because he's only suing for the last month. If he's suing for the last month, I mean, he's probably going to the court in order for the court to determine if there's a partnership or not. If the court determines there's no partnership, well, you know what I mean? He's not going to get any more. You know what I mean? There's nothing to get anymore. You see what I'm saying?
Yes.
So it's either after this decision, it's either they put something in writing or they establish some kind of employee-employer relationship document that stipulates what's going on. You know what I mean? So this is a wake-up call. Put everything in writing.
Okay. That's very lawyerish answer. Put everything in writing.
But it's true.
Okay, thank you very much. Mhm.
Okay, so how to set up a partnership. Determine if you should start a general partnership. So a general partnership is just basically what I told you. Two people come together, they have an agreement, and they put who shares profits, who shares losses, et cetera, et cetera, et cetera. Choose a business name, like you said, file a DBA if needed, draft and sign a partnership agreement. Once you go into the partnership agreement, everything under implied partnership. So anything, all this information, how you're going to share profits, how you're going to share losses, joint control, management control, all of this should go into your agreement. Okay. You obtain your license, permits, and clearances, of course, get an employer identification number, get New York State tax identification number. Okay. So the IN is your employer. That means, any employer, you're supposed to pay like certain fees for your employees, like for workers' compensation and taxes and all that. That the EIN is for your employees. Your tax identification would be for the partnership. The advantages of having a partnership: 2 heads or more are better than 1. Your business is easy to establish and startup costs are low. Startup costs are low. Why? Because you have more than 1 person. So technically you have 2 or more people pooling in money. And when people see 2 or more people pooling in money, it's easier to get more money. More capital is available for the business because you have more people putting in money, and higher caliber employees can be made partners. So it's easy to bring another partner in. If you like somebody the way that they're working, you can bring them in.
And I have a question, actually, from one of our viewers. Can partnership hire employees?
Yeah, they
so
can.
Not as partners, but just, I don't know, as secretaries, I understand.
Law firms are usually partnerships. They have many employees. Yeah. Yeah.
Okay.
We'll get to that. The advantages continue. There's opportunity for income splitting and advantage of particular importance due to the tax savings. So basically, if you're splitting the income, your share of the taxes are going to be smaller. Why? Because you're getting a smaller percentage. Partners' business affairs are private. You don't have to disclose anything. There's limited external regulation. It's easy to change your legal structure later if circumstances change. So if you decide, okay, I don't want to be in this partnership anymore, I want to get rid of the partnership, you can basically say, okay, I'm going out as a sole proprietor, I'm going out on my own, or you can change the amount of partners you want. So it's easier to change that by changing the agreement and having everybody agree. Disadvantages of having a partnership: the liability of partners for the debts of the business is unlimited. Okay, so if you're in a partners, you and your friend open a partnership, start a partnership, your liability, and something happens and you're sued, the liability of the partners for the debts of the business is unlimited. So you're required to pay. Okay, each partner is jointly and severally liable for the partnership debts. That is, each partner is liable for their share of the partnership debts, as well as being liable for all the debts. So say, for instance, we have, again, me and a friend, we start our business, the champagne business, okay? We get into debt, okay? We decided we're going to switch, we're going to share debt 50-50. For some reason or another, she doesn't have her percentage to pay. I'm liable to pay my debt, and I have to pay her percentage of the debt also. And last, there's a risk of disagreements and friction among partners in management. That isn't really major. People disagree, but that's part of business. So if you have a good group of people working together, then it's easier to manage the disagreements. However, if you have a group of people who aren't working together, like you have 2 people, it may be harder if you're butting heads all the time. But if you have more than 2 people, then that's usually manageable. The third person usually, fixes everything. Very important, and this is going to be very important for next week. Each partner is an agent of the partnership and is liable for the action by other partners. What do I mean by agent? Does anyone know what I mean by agent?
We can ask, and we'll just wait. And there is actually a question. So let's ask our participants. So who is an agent in this situation of a partnership? And while we are waiting for the answer, we do have one question from Ladislav. Is partnership considered a legal entity, or it is considered as a contract? Direct quotation.
No, it's a legal entity. It's a contract. Okay, it's a legal entity based on a contract.
Okay, so it's a fusion.
Yeah, it's illegal based on contract. And as we discussed earlier, look what happens if there isn't a contract. You know what I mean? I don't get paid. You know what I mean? You said this, I said this. That's why you should put, all the responsibilities, everything that's going to happen based on the partnership in a contract, so everyone knows how things are going to be run, how things are going to be managed, how debts are going to be paid, who's liable for what, etc. Okay.
I understand why there is such a question, because, for example, in Russia, in UK, for example, a general partnership is considered to be unincorporated form of business, and only an LLP, limited liability partnership, would be considered a legal entity. That's why there is often a confusion. And also there is a confusion because of this unlimited or joint and several liability, because usually it's kind of unusual for a corporation, for a legal entity to have such form of liability.
Okay.
Probably.
And when you sole proprietorship, okay, when you say legal entity, you say, are you thinking, are you saying legal person or legal entity? Because two completely different things. A legal entity is a sole proprietor is a legal entity. I could say I'm a sole, and it's a legal entity. Okay, so okay, a corporation is a legal person. Okay, it makes a big difference. So a partnership, as I said, is a legal entity. It's formed by the law. There are some requirements that have to be taken care of, formal requirements, legal requirements that have to be taken care of in order to form that partnership. But that partnership, the essence of the partnership, is based on an agreement.
That's, I think, where we have this miscommunication between the viewers because of the language. Because in Russia, we consider legal entity, as we would call it, a separate legal personality, which is separate from its owners, that can sue, be sued, and can be sold as a separate building, separate, not building, separate business. So that's the whole idea. So, and sole trader or sole proprietor or general partnership would be considered to be unincorporated forms of businesses that cannot be attached or like separated from its owners. Then that's, I think, that's why was the question.
Okay, yeah, but as I said, partnerships. Okay, partnerships they're not separate. You know what I mean? They're not. They're not like corporations. We're going to talk about some of them that have both qualities. We're going to go through that in a little bit. Okay, but you know what I mean? When you have a general partnership, it's called legal entity. It's called general partnership. It's based on an agreement. Okay, we're going to move on.
We'll go to it. Okay.
And agent, there are, everybody knows what an agent, when I say agent,
yes,
what do I mean?
Agent. Yes, we have a lot of answers actually for the agent. Thank you very much for answering the question for Vladislav. So Anje says it's proxy, Ksenia sort of representative, Timur representative, Daria. Agent has the authority to act on behalf of the partnership or all the partners. Pavel says it's general manager. And yes, it's basically representative.
Okay, Sarah, your agent is a person that can legally act on your behalf. Legally act on your behalf. Okay. So just because, Sophia and I are out having coffee and Sophia says, orders food and says, Alexandra's gonna pay. I'm like, huh? She's not my legal agent. Okay. When you have an agent, there's certain qualifications that have to be there. There's certain things that have to be met. And as I said, that's going to be the next class. We'll talk about agency next time. Okay. So each partner is an agent of the partnership and is liable for the actions by other partners. Okay. So if we have a partnership, and I'm going to give you a hypo, I have a partnership, I can bind all my partners based on my actions or based on my agreements. Okay. If partners join or leave, you'll probably have to assess all the partnership assets, and that could be costly. So again, if you have a partnership with someone is leaving or whatever, it could be costly because you have to look at all the assets, who gave what, and give the person their proportion of, the partnership monies. Okay, the hypo. All right. Rita and Garcelle entered into a partnership to sell Italian shoes. The name of the partnership is Girls Love Shoes. They both sign a written agreement. Garcelle decides that she wants the business to grow. As a result, she buys shoes from an unknown vendor and promises to pay later. She did not consult with Rita before she purchased the shoes. The shoes don't sell because the vendor is unknown, and as a result, Garcelle refuses to pay the vendor. The vendor sues Girls Love Shoes. Rita says she's not responsible because she knew nothing about the sale and did not agree to it. is Rita still liable for payment if the vendor wins?
Okay, very good question. And they are in a partnership.
Yep, it's a written partnership.
And we can see that the answers starting show up. So yes, Marusia. Daria says also yes. So Vladislav says Rita is still liable because Garcel is the agent of the partnership. Sophie says yes. Dmitry, yes. Pavel, yes. Yes, and Jay, Irina, everyone says yes.
Okay, yeah.
And Olga.
Because she's a partner. She's an agent. You know, every partner is an agent. So she can bind the partnership. Okay. Very, very important. We have, a lot of times we have people here in the United States. Someone may come and, you know, a department store sends somebody to come and fix a refrigerator. Okay. And the person comes up and, you ask them, how do I know you're an agent? You know what I mean? They have to have a badge. You know what I mean? So there are some legal requirements that, require that someone becomes to identify how someone is someone else's agent. Okay. Limited partnerships, limited LPs. A limited partnership involves a general partner who typically runs a business and assumes all liability, and also has a limited partner, a silent partner, who contributes capital but doesn't participate in day-to-day operations. Silent partners typically earn a proportional share of profits, and their liability is limited to their initial investment in the company. Okay? So that's a limited partner. So you have a silent partner. I'm interested in restaurants. I know somebody's going to open a restaurant. I give, 30% of the startup cost. I don't go into the restaurant. I work all day as a lawyer. I come in and get my profits at the end of the month or at the end of every quarter. And if there's something that goes wrong, my liability is limited to that 30%. So the other partner, his liability is basically he assumes all liability. He assumes all liability. So absent my liability, everything else is his. That's a limited partnership.
Limited, can I clarify? So limited partnership, it means that you can limit the amount of input and output that every partner gets.
Yeah, basically that's you have a silent person. You know what I mean? I don't want to, you know what I mean? I'm not a restaurateur, but it looks like a great business. I'm going to give you, $20,000.
Like investment, like investor or
it's more
something.
of an investment. Yeah, exactly. Yeah, that's a limited partnership.
Because we would understand, I hope I can speak for our viewers, we would understand it differently. We would understand that general partnership is like unlimited liability, where every partner has this joint and several and unlimited liability. And limited partnership, we would understand that it's like a halfway house in between a company and the partnership, where it's a partnership, you pay income tax from your share of the profit, but you have your liability limited like in UK. So it's a different story here.
It's totally different, yeah. So, but we're going to get to it. Yeah.
Okay, thank you.
Okay, types of partnership with limited liability partnership, LLP. Okay, this is very important. A limited liability partnership is a partnership in which some or all partners have limited liabilities. It therefore can exhibit aspects of both partnerships and corporations. Okay. In an LLP, each partner is not responsible or liable for another partner's misconduct or negligence. And you find this usually in professional settings, accountants, lawyers, doctors. That's where you have LLP. So a lot of law firms, you may have Smith and Gold, they have LLP. So say, for instance, I'm a partner in a law firm and I do something very, very egregious. Okay. And I get sued. The other partners are not responsible for that debt because it's a limited liability. Their liability is limited.
Their liability, not the liability of the whole partnership, but their
not the liability of the whole partnership. No, not their liability. Well, I mean, hold on, let's go back.
Yeah, but it makes sense. Yes, if it's their liability is limited, then the whole partnership is it's kind of understand. Yeah,
the partnership.
Silly question.
Okay. Advantages of creating a limited liability partnership: you're protected from another partner's negligence. That's very important. Flexibility in business management structure, relatively easy to set up. Partnerships are not that difficult. Advantages. Creating an LLP, LLPs are not recognized. Disadvantages, excuse me. LLPs are not recognized in every state, may be restricted to certain professions. Like I said, LLPs are usually for professional entities. So basically, if you're not a lawyer, a doctor, or whatever, or a veterinarian, you may not be able to open an LLP in a particular state. LLPs must have at least 2 partners, which is what a partnership is, 2 or more people, must have a managing partner, but all partners must help run the business. And the managing partner is in charge of the day-to-day running of the business. So an LLP must have a managing partner. So if you go to a lot of law firms, you may be introduced. This is John Smith. He's our managing partner. So John Smith manages everything that goes on in the law firm, okay? Mm-hmm. State filing requirements are sometimes more complicated. Again, it depends on the state.
Okay.
Okay. All right, so this is one of our polls. Maybe we could start. D and P start a business. P contributed 50% of the startup cost. She has nothing to do with the daily operations of the business. P is a what?
And we don't say what kind of form of business it is, whether it's general, LP, LLP, just
and
like
nothing
any.
to do with the daily operations of the business.
Mm-hmm. Okay, so the question is for everyone. Yes, let me just voice it again. While we're waiting for the answers, start a business. It's definitely some form of partnership. So P contributes 50% of startup costs. She has nothing to do with the daily operations of the business. What P is? General partner, limited liability partner, a limited partner, all of the above. Mm-hmm. So you can just write abbreviation, for example, or the number 1, 2, 3, 4. Okay. Actually, we have quite a lot of answers already, and Olga, Irina, Marusia, Vladislav, Tamara, everyone, Daria, Olga, Natalia, Camila, everyone says, except for Natalia. So everyone says that it's 3, a limited partner.
Yeah, she's a limited partner. Excellent. Very, very good. Excellent.
Good. Mm-hmm. Thank you, everyone.
Okay, so now these are corporations. We're going to start on corporations. Okay, so this is basically what Sophia wanted to really, really concentrate on, and they're important, but I'm not much of a corporate person, so we're going to go. And I wanted to say next week for corporations, we're going to discuss how to manage them, but this week I'm just going over the basics of a corporation, and this is where Delaware law comes into, okay, comes into play. Okay, a corporation is an artificial person. Artificial person. It can sue or be sued, pay taxes, distributes profits to shareholders. So it's a person. It's not an entity, it's a person. Okay.
That's where we have this confusion, because there is this question, because for us, a legal entity is a separate person. That's why for us, entity is bigger than a person. It prevails over. So it's like for us, the word maybe. So that's everyone. For us, it is important. In United States, a legal person is a legal entity. So it will be just easy for us. Yeah. So in terms of Russian law, so if I may say so.
Okay. Mm-hmm. Yeah, so it's an artificial person. So like I said, it can sue, it can be sued, pay taxes, distribute profits to shareholders, etc. A corporation is separate from its owners. Its strongest protection for its owners from personal liability. But the cost to form a corporation is higher than other structures. So it's more expensive, but I mean, you have the most protection because it's a separate entity. You know what I mean? So if you are part of a corporation or you have shares in a corporation, running a corporation, whatever, something happens, the corporation is sued. You are not sued. So say, for instance, Alexandra Dulce is doing business as Champagne Queen, okay? Incorporated, something happens, Champagne Queen is sued. Champagne Queen's assets are vulnerable, but my personal assets, my house, my bank account, my car, they're not vulnerable.
Okay. I think we know, Alexandra, what kind of drink you like now.
All right. So stocks, we have to talk about how, you know, basically the premise of raising money for corporation, okay? A stock, capital raised by corporation through the issuance of shares. So you give shares, okay? Shares, units of stocks issued by a corporation that represent ownership. For example, the champagne store issues stock and a buyer purchased 10 shares of it. If each share represents 1% of ownership, of the company, the buyer owns 10% of the company. Okay. So stocks, it's capital raised. Okay. And people buy shares. So people are selling stocks and people are buying shares. Understand that? So
I think a lot of people, if I may be an agent from our, or like a proxy of our participants, I think a lot of them would be confused because we very often thought, a lot of people usually think that stock and share is the same. So it's just more American term for shares.
No, okay. So basically stocks are capital raised. It's like, basically you buy, a person buys stocks and owns shares. You see what I'm saying? You buy stocks in order to own shares.
So share is like доля and stock is like акция. So stock is like a paper, yes, if I may say so, and share like a part of business, sort of.
Yeah, so basically, so that's the stock, this capital raised. Okay, so stock, you're raising money, shares, this is what you own. This is exactly what you own. Okay. And some people, and like I said, some people do, like I said, in the US too, some people do use, I own stock in this company. Okay. I own stock. How much stock do you own? 3,000, let's say I own $3,000 worth of stock. How many shares is that? You see what I'm saying? Okay. So I own $3,000 worth of stock, but how many shares is that? Is that 10%, 1%, 0%? So that's how you have to start thinking. Shares is exactly what you own, what percentage you own. Yeah, that's the percentage. So shares is the percentage. Okay.
That's why we say share capital of the business, not stock capital. It's share.
Okay. A dividend. A dividend is a sum of money paid regularly, usually quarterly, by a company to its shareholders out of its profits. Dividend payments and amounts are determined by the company's board of directors. So usually the amounts are determined by the board of directors, but usually it goes by the percentage of the shares that you own. Okay. Incorporating in Delaware. Okay. So Delaware is the heaven for corporations, and this is why. The incorporation process is different in all states. However, most companies incorporate in the state of Delaware because the most famous reason Delaware has attracted the eye of corporations across the world is lenient taxes imposed by the state. Corporations registered in Delaware that do not do business in the state do not pay corporate income tax. Okay? So if can
we have an explanation? What does it mean, lenient? Yes, because
lenient,
it's a difficult
when we say
word.
Lenient, that means very relaxed. Lenient is very, very relaxed. You can very relaxed laws. Okay? So say, for instance, I decide to incorporate, Alex's Champagne Inc. And I said, you know what? I'm going to go to Delaware, but I don't do business in Delaware. So I don't have to pay Delaware taxes. You see what I'm saying? And so say, for instance, I did the same thing. I incorporated in New York and I incorporated in New Jersey. Okay, I incorporated in, I live in New York, but I incorporated in Jersey. Say, for instance, Jersey doesn't have that. The fact that I incorporated in Jersey, I still have to pay Jersey taxes. Okay. And the problem is the double tax. In New York, I'm paying for doing business in New York, and I'm also paying taxes for being incorporated in New Jersey. So if you incorporate in Delaware and you do not do business in the state, you do not pay corporate income tax. Okay.
Which is excellent. Yes.
And that's why a lot of people go. And again, guys, please, a lot of people have this issue. The principal place of business and your corporate headquarters are two completely different things. Okay. My principal place of business could be New York. I could do all my business in New York. My corporate headquarters should be in where? Delaware, because I'm incorporated there.
But what happens if you, for some reason, suddenly have a client from Delaware, or you decide the client from Delaware doesn't mean that you do business in Delaware, yes?
Yeah, just because it doesn't mean you do business in the state of Delaware. No, it doesn't. You know what I mean? Where you do business, you could have clients, where do you predominantly do business?
That's the thing.
Yeah.
Okay.
Reasons to incorporate in Delaware: privacy. As with registering a business in most states, companies must assign a registered agent. That's someone who maintains a physical address to be the official address and receive mail and collect paperwork. Unlike most states, however, in Delaware, the registered agent is the only name that must be disclosed in association with the company. Other officers and directors are not required to disclose their names, allowing an extra degree of anonymity. Because of this lack of reporting, officers, directors, and shareholders are also not required to maintain residency in Delaware. So also privacy. So you can have, a company, you could be an officer of a company in Delaware, and that information, no one can find that. Oh, it's going to be very difficult to find that information.
Mm-hmm. Okay, and I wanted to say that if anyone has got any questions, you may write it in our comments and we will ask. So, Alexandra, for now there is none, so we may go on, but just for the future, because it's a very interesting topic. Mm-hmm.
Okay. It's quick. Often the incorporation process can take less than an hour to complete, okay? To make things even easier, Delaware allows only one person to hold numerous positions in the company, such as the role of officer, director, and even shareholder. So you can be a director, you can be an officer, and you could be VP, the vice president, you could be a director, and you could be a shareholder. Okay. In other states, this can often only be accomplished with sole proprietorships or LLCs. Okay. So very, very important. So you could have multiple. So you can, you can start a corporation and, it could start small and you can be a shareholder, you can be an officer, and you can be a director.
Okay. And we actually have a question.
Please
but I think I will ask this question after you read the next reason, because it's kind of connected, I think, with it. So let's go to the next one, and then I will ask. Mm-hmm.
Corporation court. Instead of traditional trial system, corporate lawsuits in Delaware are resolved by the Court of Chancery, a court made up of judges who specialize in corporate law. Because of this, Delaware has a well-developed and predictable legal precedents that may benefit corporations. While the average civil lawsuit may take several years to resolve, Delaware uses judges instead of juries, and prioritization of corporate-related cases means similar cases can be decided more quickly. So you have a special court that just takes care of just corporate law. So that's why Delaware is a corporate haven for most people. You were going to ask a question? Someone's going to ask a question?
Yes. There's a question from Vladislav, and it's actually about the liability. Shareholders, says Vladislav, are not liable for the corporation's debts. Is it absolute?
Remember, a corporation is a person.
So, and is it absolute? Else. Yeah. Or do you have some cases of the piercing of corporate veil when the shareholders are held liable for
and that's gonna
instead
be
of a corporation?
That's going to be next week. We're going to discuss that next week. We're going to.
Okay, Vladislav.
Yeah.
We will answer your question in 2 weeks. Okay. That's a long time to answer the question.
That's the next one. I'm going to talk about corporate governance and all that. Yeah. Piercing the corporate veil. Because, they always say you can't pierce the corporate veil. You know what I mean? You can't use the corporate veil as both a shield and a sword. So, so that's going to be next time.
Okay, Vladislav, we'll wait.
Okay. So this is going to be one of my famous slides. The most popular reason people incorporate in Delaware is, we all know, tell me.
Okay, so we are waiting for the answers. The question is, the most popular reason people incorporate in Delaware is 1, 2, 3. Disputes are decided quickly, takes less time to incorporate in Delaware, tax obligations are more favorable in Delaware. So it's basically reflecting back to the information that Alexandra has been providing to us. So, and basically everyone listened to you, Alexandra, very well, because everyone says that it's Bella, Olga, Dmitry, Daria, Zhnev, Vladislav, it's number 3, tax obligations. Are more favorable.
That's why Delaware is so popular. Okay, how do you incorporate in Delaware? Again, same thing. Choose a name for your business. Sam's Ice Cream Palace, Inc. Designate a registered agent in Delaware. And your registered agent usually receives your legal documents. I always tell people, if you have a registered agent in Delaware, make sure that the person you have the correct address, and you make sure that the person is reliable. Because say, for instance, you get a summons for a court appearance or something, and your agent isn't there or they're not responsible, that could put you in a lot of trouble. So know who your registered agents are. File a certificate of incorporation in Delaware, create corporate bylaws, appoint corporate directors. All of that is going to be next week. A couple of weeks from now. Hold your first corporate directors meeting. Authorize the issuance of shares and stocks, obtain Delaware business licenses and permits, and get an EIN for your business. So that's basically it. And like I said, this is very similar in other places also. There might be one or two, but basically the importance of Delaware is that it's very, very corporate friendly to the point where it has a corporate court, okay, to hear cases. Not every state has a corporate court to hear cases.
Mm-hmm.
Very, very important.
We have a question. Yes, we have a small question before we move on. The question is from Olga. Is registered agent, can it be only a person or it can be also a company?
A registered agent could be a person. You know what I mean? I could be your registered agent. It doesn't necessarily.
But does it have to be? Does it have to be a person or it can be a company?
A company, but most people, when you say registered agent, you don't think of a company, you think of a person. You know what I mean? Because the person has to sign. So yeah, you could there are probably companies that work as registered agents. You know what I mean? ABC registered agent company. You know what I mean? So all your paperwork and everything goes there. Yeah, that could happen, but usually registered agents are a person. You know what I mean? Sam Smith, registered agent, whatever. And Sam Smith may be a lawyer, may have a maybe a solo practitioner. And Sam Smith decides that he's going to be the registered agent for some companies. So all the paperwork goes to him. And as soon as it gets to him, he signs for it. And it goes to the corporation's legal department.
Okay. So I think a lot of people who are residents of Delaware, basically the whole state may be full of registered agents of so many companies.
Yeah, they probably have a lot of them in Delaware. I mean, very, very popular. You know, you have, you know, some law schools, you know, you have the option of taking corporate law. In Delaware, you have to take corporate law. I mean, you can't get it. I mean, that's what they do. That's their trademark. And Delaware is a very, very small state, a very small, insignificant state. So corporations is what's keeping it going. Okay. So now we're going to talk about types of corporations. So we have the C corporation. Okay, C corporation has a board of directors that is responsible for guiding business decisions. Okay, the company is taxed as an individual entity or individual person, and employees and shareholders are taxed on their personal income tax. For instance, I work for Target department store. Target pays taxes, and as an employee, I pay personal income tax, double tax. You see what I'm saying? So Target is paying a tax as a corporate person, and I'm paying a tax. So there's a double tax. Is that, everybody understand that?
Yeah. So they paid profit. They paid tax on the profit corporation. Then they paid the salary to the employees, and the employees pay personal income tax from the money that they receive from Target. That was already taxed.
Yeah, exactly. Yeah, exactly. That's double tax. Okay. So the most significant thing about a C corporation, it has a board of directors that is responsible for guiding its business decisions. Okay. So a C corp has a board of directors. It's important. Okay. If you eventually want to go public and sell stocks on the stock exchange, the C corporation is the best way to go. And why do you think that is? Why do you think that if you want to go public and sell stocks on the stock exchange, C is the best way to go?
We can ask our viewers.
Yes.
So a question, everyone, for you to keep you alert. So why C corporation is the best way for the future if you decide, for example, to go public and to set up or change to a PLC, public limited company, or you decide to go public, become a listed company and sell your stocks at the stock exchange and so on and so forth. So we'll wait for this answer because it takes, remember that we have a small delay in our, so we'll wait for the answer, and that is interesting for us. So, and we'll see how everything goes. And there is sometimes an expression as pass through taxation. This is
We're going to talk about that next.
Okay.
Right next.
Okay. So, you know, Alexandra, there is not a single answer yet.
Okay. So basically, if you go public, right, that means you're getting the public money. People are giving you money, right? You're selling stocks, people buying stock and having shares in the company. Okay. You need a board of directors that's responsible for guiding the business decisions. You see what I'm saying? So you can't just have nobody running the corporation. You have to have a board of directors, because people are getting, people are giving you money. People need to know that, you have competent people making competent business decisions.
Okay, but sometimes, there is like one person who is the head of business, and he or she may be considered also from the point of view of doing business as a reliable person, and they may bring money to this person. So a board is better in this point of view.
I mean, like I said, if you're thinking in terms of corporation, you need to know, because a corporation has a board of directors. They make the business decisions. So, I mean, if you're going to be taking people's money, you need to be able to document that. You need to have people who know what they're doing. So this is why it's the best in order, if you want to go public, for you to have a C corporation, a C corp.
Yeah, and Olga also, I think, supports you in this, because she says that it is transparent. It's more transparent than some companies that was set up in Delaware, where there is no disclosure of information about the director and so on. Yeah. So if we speak about a small one.
Very good.
Okay.
All right. So now we have an S corporation. Okay. S corporation is a separate legal entity with a government structure similar to a C corporation. So an S corp does have a board of directors, but like the sole proprietorship and partnership, S corps are pass-through entities. Okay. Pass-through entity means that the shareholders claim business profit or personal on personal income taxes. This avoids the double taxation. Okay. So that means that when, say for instance, again, we use Target makes a profit. What happens is I get my share of that profit and I'm taxed on it, and Target is not taxed. This avoids that's pass-through entity. That's a pass-through entity. Okay. And you can do that with a partnership, and you can do that with a sole proprietorship also. No double tax. All right. Kind of the limitations of one is that you can only have up to 100 shareholders. So, with the C corp, they have plenty of shareholders, you know what I mean? But this, you could only have 100. This makes it difficult to raise capital through the sale of stocks. If the number of people that you have is limited, then you can't make as much money. You know what I mean? If you want to raise $1 billion, for instance,
you cannot.
And you could only have 100 people, it's very unlikely that 100 people are going to come up with $1 billion. Okay. Shareholders in an S corp must reside in the United States. Okay. And S corps only have one class of stock. C corps can offer different classes of stock that gives preferential treatment to shareholder votes and offer different dividend benefits. I'm going to talk about classes of stock next, but very, very important. There are so many different types of stock. I'm going to give you example of 3. Okay. Preference share. Okay. So a preference share gives their holder a preferential right to a fixed amount of dividend, meaning that they will receive dividends ahead of ordinary shareholders. Okay. Preferred shareholders also have a higher priority claim to the company's assets in case of insolvency, excuse me. So preference, just the name itself. Okay. That's it. Non-voting shares. Non-voting shares do not give the holder any voting rights to the company. It means that the holder is entitled to a portion of the company's capital, but is not able to take part in general meetings. Redeemable shares. Redeemable shares are shares that can be bought back by the company at some point in the future. The redemption date can either be fixed in advance, 3 years or whatever, or decided at the company's discretion. The redemption price is usually the same as the issue price, but not always. Okay. Now,
that is an interesting type of share.
And I was looking at redeemable shares, and the fact that I can buy this and you can give it back to me within 3 years at the same price, in your opinion, does that seem very profitable? Or is that something that you would go? I mean, if you're going to buy shares, why would you buy shares? Tell me.
To receive dividend.
To receive dividend. All right.
For some people, if it's an investment, so you may receive some money, or you hope that someday you will sell them for higher price. So, and that is usually, I think, more often the reason. So
and I agree with you. But say, for instance, I buy redeemable shares, okay? And I buy my redeemable shares and I pay, they tell me that, I can redeem them in 3 years. And in 3 years, I redeem them, but I get the same money back that I bought them.
So it means that the dividend, and Daria Vladislav support me on this, so maybe the dividend will be like really great or expected. So that is the reason. Or maybe this way you are protected from any falls in the price. So, but this is kind of weird, situation.
It's weird. So. It's definitely what you may call it, the redeemable shares, because my assumption is that if you redeem them and I bought them, you're going to give me some kind of profit. Okay, so let's hold on. Let me see. Non-voting shares, like I said, one thing I want to say about share types of stock in general is that companies and corporate boards can decide what type of stock, what kind of shares that they give. So they give shares different types of names. Like I said, there's, some types of shares are called A, B, C, D shares. You know what I mean? So it's not like a fixed vocabulary. There could be all types of shares depending on how the company is structured and how it wants to take in money and how it wants to give out money. So I only gave you 3 examples here. But, these are basically, there could be you can look online, you can see a lot of different types of shares and a lot of different types of stock. Again, it depends on the company and how they want to receive money and how they want to give money back. In my opinion, redeemable shares are not the way to go. Okay.
We have some answers also. So speaking about redeemable shares, is that you earn dividends, Marusha says, during that period, and then it's profitable basically because you risk nothing. They're going to they promise you to buy them for the same price. And Pavel says that it's like option contract. So, or when you receive an option, might be like this. And Jess says, asks actually, there are actually questions about these shares. So are redeemable shares easier to issue rather than other obligations? And there is another question, is there higher interest rate offered for redeemable shares?
Yeah, I mean, interest is not even an issue. Someone said something about, that, you get dividends and then you risk nothing. That's true. You get dividends. And then after that, you know what I mean? You get your dividends. And then after that, you know what I mean? You buy it back as the same price. Okay. So it's like buying a pair of shoes. You know what I mean? You wear them and you enjoy them. And then after that, you give them back and then they give you back your money. But in terms of, which makes sense. However, I would think that, I get dividends, but other stocks get dividends also. Other stockholders, people who own other shares get dividends also. So it's not, the dividends are not exclusive to redeemable shares. You see what I'm saying? So it's like, okay, fine. All right. I'm getting dividends. Everyone else is getting dividends also. What's the big deal?
And basically, they do not go high in price because they will buy them from you for the same price. So that's kind of.
My logic is, you're trying to raise capital. I'm buying shares for you. I'm helping you raise capital. Okay, fine. You can redeem this, but at least even if you give me 1 or 2% on the money. Okay. And I know, again, everyone is thinking, okay, we get dividends. You probably get dividends or whatever, but that isn't, like I said, that the dividends aren't exclusive to redeemable shares. So that's my problem with redeemable shares. I'm just like, what's going on here? Okay. That's
just so as I understand, just an example, sort of. So how?
Yeah, it's an example. Like I said, and this is very, very important to know. I just gave you 3, preference, non-voting, and redeemable. But there are a lot of the companies issue stocks and name stocks based on the amount, the money that they want to take in and how they want to give the money out. So remember that. Like I said, I saw an example of stock called ABCD stock. Okay? I didn't, you know what I mean? So ABC could stand for anything. So the type of stock is based on, so companies could create their own stock and say, illegally, we're gonna, get a legal format, and this is the type of, stock we're gonna issue. We're gonna issue it this way, this way, this way, and call it anything that they want. So I'm just giving you examples, okay? So the best type of stock to own is what?
Okay. So there's a question, everyone. So if you still have strengths, the question. We have like 20 minutes left. So we have got 20 minutes left. So, and the best type of stock to own is A, preference or preferred shares, B, non-voting shares, and C, redeemable shares. So, and what is interesting is that everyone is now voting for A, but we have people who say C is great. So someone likes the redeemable shares, Alexandra. So,
but the person who likes the redeemable shares, give me an example. What's the benefit of the redeemable share?
So, Pavel, there is a question to you. So you may write it. Why did you choose redeemable shares? And we will just wait, and we'll go further, and then we'll get back to your answer.
Okay.
Okay.
So while we're waiting for the answer, let's talk about close corporation.
Oh, there is already answer from Pavel. He says, because you're not risking anything. So.
No, you're right. You're not risking. In a way, you're not risking anything. But what I want you, in terms of how my lawyer mind is working, preference or preferred shares, they get dividends. Non-voting shares, they get dividends. ABCD shares get dividends. Redeemable shares, okay, they buy it. Yeah, they buy it usually at the price. But a lot of times too, remember, if a company goes belly up, you are risking something because they can't they can't buy it back. Remember that. Nothing is guaranteed. Nothing is ironclad. Remember that. So that's very, very, very important. Yeah. Okay, close corporation. So there's C Corp, S Corp, and a close corporation. Okay. Close corporation, they're not publicly traded, so they're not like a C Corp. And if they're not publicly traded, what don't they have?
So, well, they don't have obviously shares.
They don't,
so
not
they don't
that,
sell.
but they probably don't have a formal corporate board of directors either. Okay.
Okay.
Remember, because I said the board of directors is important, because if you are taking people's money in and giving money out, you need somebody to be able to make decisions and do that in a very proficient manner. Okay. So close corporation, they're not publicly traded and also known as privately held companies or family corporations. Okay. They have more flexibility to operate and looser governance rules, which gives shareholders flexibility associated with partnership. Okay. So it's more like a partnership. We make a decision. It's not like official board of directors. So that's why they're not publicly traded. So board of directors is very, very important in terms of trading. Okay. Pros of close corporations: fewer formalities. The most obvious advantage to a close corporation is fewer rules to follow. You still must abide by the regulations concerning the filing of incorporation documents, but beyond that, owners can focus on running the company instead of worrying about corporate regulatory compliance. Okay, so it's very, very, very important. If you are, if you have a close corporation, whoever is running it, so like I said, usually a family, they're not the corporate board. The corporate boards can be very, very complicated. And it could be a very, very messy situation because you have a lot of people giving different opinions, one, and you have the concept of, like we talked about, the shield and the sword, piercing the corporate veil, and you can't use the board as a shield, and so with the close corporation, you don't have all of that. Okay. Limited liability. In general, shareholders of a close corporation are not personally liable for the business debt, which is good. However, there are exceptions, such as when a shareholder has signed an agreement to be personally responsible for corporation debts. I want somebody to give me an example when you think that a person would agree to be personally responsible for corporation debt.
Okay, that's a very good question. So a question is, so everyone, we have a little bit of time left. So when may a shareholder voluntarily, we are speaking about voluntarily, yes, Alexandra?
Yeah.
Would voluntarily sign an agreement to be personally liable for corporation debts in, so to give up this limited liability in a closed corporation? When would be a hypothetical situation? When might this happen? Anyone? So it will take time, I assume, Alexandra. So,
we have time.
Marusia says that if they are the main beneficiary.
Be specific when you say main beneficiary. I don't.
Okay, Marusia. So we need to specify exactly what does main beneficiary mean. We'll just wait. Okay. So Ladislav says that maybe it will be personal surety, babyship or something for the bank loan or something. That would be maybe a situation.
Okay. Anybody else? One more thing. Somebody, what does she mean?
We'll just remember that there is this small delay when we're speaking on YouTube, and there is like 20-30 seconds sometimes it requires for us to actually, for the viewers to see us in reality. So speaking, Pavel says that if he or she is the majority shareholder, and Marusia is specifying the expression main beneficiary, she would say that they are entitled to the to most of the profit.
Okay. All right. Okay. Let's say. All right. Okay. In terms of, remember, what did I say this was? This is what? Family corporations. Okay. They're very small and they're usually owned by family. A situation where you would have a shareholder sign to be personally responsible for corporate debts. Say you have a family business. Okay. And that family business has been in your family for generations, and you want to keep that family business going, and there's a situation where you need money, okay? And one person has more money than the next, and in order to keep the business going, they take on the responsibility for corporate debts, okay? There is somebody had said something about they take the responsibility of corporate debts and they get
most of the profit. Yeah.
The main profit. I mean, that could work, but if you're dealing with a family in a family or close situation, most people in those situations, most people tend to try to split the profits equally. You know what I mean? Try to keep everybody. They don't want one big person in charge because they like running the corporation together. You see what I'm saying? So basically, I would say that in a situation where the debts are large and someone has a lot of money, they say, okay, this has been in the family for a long time, or I really am into this business, I believe in this business, I'll take on the responsibility for that. That's usually in a situation where that happens. In terms of taking debt on, if you're taking on corporate debt, doesn't necessarily mean that you're going to get a bigger share. Yeah, you really don't. Taking on debt doesn't necessarily mean you're going to get a bigger share. Like I said, especially with a closed corporation, you're a group of people working together. You know what I mean? You probably know one another. You're probably family, et cetera, et cetera. So one person like taking on everything and taking most of the money, that's usually not the landscape. So, okay. So it's usually somebody that wants things to continue. Okay. Look, the pros of closed corporations: more shareholder control. With fewer shareholders and relaxed corporate structure, a closed corporation provides each shareholder with more control over shares. For example, if one owner wants to leave the company, the other shareholders can better control those shares. Okay. So say, for instance, if somebody, we have a large company in C Corp and somebody wants to leave, and that person is an initial share, bought initial stock, and now they own their stock is worth, and this is just an example, 30%, right? And they want to leave, okay? And what would happen? That means 30% of the company's stock, or the 30% of the company's what? Value would walk away with this person, right? But depending on how much that 30% is, what would happen? The C Corp would have to what? Issue new shares, find more funding, et cetera, et cetera, et cetera, talk to their current shareholders. So it becomes more problematic. But if the owner wants to leave the company, other shareholders can better control because there's a smaller pool. If there's a smaller pool of people that have money, what does that mean? It 100% only goes so far. So it probably means that if there's a smaller pool of people, you know what I mean? The shares are probably more even. You know what I mean? So if the shares are more sold evenly, so you're not going to have one person that owns like 30% or 40% or most of the
Oh, you mean in this way? Yeah.
Okay. So if the person if a person that, let's say somebody owns 10% of the company says, I'm going to walk away, it's easier to fill in that gap. That's basically, as opposed to somebody walking away with 30% or millions or billions of dollars. That's basically.
You never know, sometimes there might be even a person with 30% walking away, but still, yeah, it's understandable.
No, usually, you know what I mean? Like I said, remember the culture. We're trying to talk about the culture here. When you think of a close corporation, we're not thinking about, Coca-Cola or Pepsi or wherever. We're thinking about a little family-owned business, or a family-owned business that has grown. Somebody decided that they were gonna sell champagne.
Yes, or go to college probably. Yes, to study.
Something like that. You know what I mean? So you have to, and corporate culture is very, 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 very important. You know what I mean? Because the corporate culture of a close corporation, the corporate culture of a C corporation are totally, totally, totally different. And that's a question I'm going to ask you guys. What do you think that how the corporate cultures will be different? Because it keeps on coming. And I want you to understand corporate culture because that plays a lot in how the close corporation is managed. When I say corporate culture, what do you think the differences would be? Or what do you think corporate culture is?
And I think that is a very good question in general to speak about corporate culture, because for us, we will wait for the answers from our viewers. If what is a corporate culture, the question was, because when we speak about business, in many things we are thinking about money, about distribution of profit, about liability, debt, and so on and so forth. So, and those who are experienced more, they would think about corporate culture. But for us, corporate culture is associated with corporations, not with a small family business.
Yeah, that's
mostly, I would say. Yes.
But corporate culture. When I talk about corporate culture, I talk about how things are run, how people are treated, how people interact with one another.
Yes, and we do have a couple of answers. So
go ahead.
It's Vladislav said it's some ethic rules or code of ethics. So it's an ethical issue. And Marussia says that it's a kind of a general approach how you run business, policies and practices.
Exactly.
And Pavel says that large difference, control rules, company views, and policies. So it's very interesting.
Yeah,
Thank you very much,
the policies, the way you do things, the way you treat people, etc. So in terms of, if you're thinking about a C Corp, the C Corp is what? It's a big corporation. It's about making money. It's about making profits for all its shareholders because it wants all his, a lot of times you'll hear, what I mean? I need to make my shareholders happy. That's what you hear when you have a C corporation. It's all about the profit or whatever. A close corporation doesn't operate that way. It's a smaller business. It's more family. It's smaller. It's more of a community base. So the corporate culture is not always money. You know what I mean? So, if one person wants to leave the company, the shareholders can control those shares and say, okay, I'll buy more shares or whatever. It's easier to control, to make a decision, as opposed to somebody in a C corporation. And you're just like, okay, there's a bigger hole here to fill. How are we going to fill it? What are we going to do to fill it? It's just easier to control. More it's easier to control the process. It's easier to control the money because people are usually smaller. These companies are usually smaller. They're more relaxed. Their policies are more relaxed. They're more friendly with one another, et cetera, as opposed to the big companies. So, more freedom. Without having to comply with corporate regulations, business owners are free to operate the company exactly as they want, such as exploring new markets or donating profits to charity without consulting a board of directors or answering to public shareholders. The closed corporation shareholder agreement should detail important aspects of its management and financial structure. So that's very important. You know what I mean? So when you have a C corp, there are mega corporate regulations. You know, who you give money to, how you give the money to, where it's going, et cetera, et cetera, et cetera. If you own other companies, how is that being regulated? So there are a lot of regulations for corporate, and the corporations, C corporations, have to file a financial disclosure form, I believe, every year, and it's really intense. It's really, really thick. It has a lot of information. The closed corporation doesn't have to do that. So they can take their money and they can do whatever they want. They can explore new markets. They can advance. They can grow. When they're giving,
and Alexander, we have a question.
Go ahead.
Yeah, we have a question about like I understand that it's a kind of it might be difficult question from Yelena, actually, from our Telegram channel, and how many are there a lot of these closed corporations in US? Like if you speak
there are
about
a lot of them. Okay, I'm gonna tell you. I'm assuming that there are, and this is because I haven't had count.
Yeah, I understand that it's you don't have the statistics, but just like do you encounter?
I'm pretty sure they're more popular than we think, simply because not every corporation could be Pepsi-Cola, not every corporation could be Coca-Cola, you know what I mean? So there are a lot more, you know what I mean? Especially, I would say, more so in Middle America, where people are more apt to own, family businesses, farming, agriculture, industrial things. So I would say more so in mid-America than both of the coasts.
And I have a question from myself personally. So when you do encounter in your work with different contractors, with different companies, when you look at the name of this company, there is like, do you know what corporate structure they have or not? So when it's like Inc., you do know if it's S corporation, C corporation, closed corporation, you don't know this.
Incorporated. You don't know. If you want to know, it's easier to go to, like, you find out where they're incorporated, and you find out you can get all that information online. It's very easy to get that information online. But initially you just see incorporated.
And that is also, you don't know what it's inside over there. That's an in. Then of course it's understandable.
So we have about 3 minutes left. I think this is what I was thinking at the end. Which, if any, is the most popular corporate structure in Russia?
Okay. That is such an interesting question. What would be, I would say, because we have a different corporate structure in Russia. And everyone, we do have a last question. So as I understand, so what would be the most popular corporate structure in Russia? C as closed corporation, none of the above. And while we're waiting, there is a very popular question coming from Tamara. So why are they called C corporation or S corporation? What would be a reason? So
that's a very, very good question. And I did not look that up. I've just read S corporation and just look at their.
I think I can answer this question, then I can help, because we were just doing this yesterday with some of my students going through corporate law. So, and it was I Googled it just because I had the same question as Tamara, because it's actually the number of the name of a paragraph in taxation regulations. So when you incorporate and you go to the taxation office, and it's just section C or section S, and that's why you accordingly choose the taxation for your business, and based on this taxation paragraph in taxation documents, you just choose the status of a corporation. That is all, Tamara. So it's just
very, very good, because when I was looking at the and I've studied corporations, I studied school and everything, but I was just like, a C corp. I just, like I said, I know the personality of a C corp, but I never.
And usually the practitioners, they work so often with them, so they don't even think about it because it's so natural. And we are the outsiders who study the language. We always think that maybe it's abbreviation or something. That's why we like asking such questions, because of this. So. Okay, and now the answers are very interesting. So some people would say none. So someone would says S corporation, And a lot of people actually would go for S corporation, but a lot would go for C, but they're not sure. So that is a story. So C corporation.
The C corporation would be most popular in Russia as opposed to a closed corporation?
Yeah. So, yeah.
Really?
So, yeah, a lot. So, because I think it's more, I would say that it just sort of corresponds more with what a Russian type of company would be. That's why it's more understandable maybe for
with the board
some.
of advisors and the issuing stock and managing stocks and all that.
Yeah, so just a lot of maybe people are dealing a lot with this type of companies. That's why it's more understandable, because we need time to digest and understand this more. So, and maybe also a lot of Russian lawyers have heard more about C corporation just because a foreigner can set up this type of corporation. For example, speaking about S corporation, a foreigner, if we speak about some startups or venture companies, cannot set it up because they're not residents of US. That's why it's
saying this. Okay, I see more corporate. Okay, because I for some reason or another, I thought everyone was going to say closed corporation. But when I think of Russia, I think of more like a family coming together and owning a business and trying to do that, as opposed to the C corporation culture.
Yeah. Maybe I think maybe it's just a guess, because for a lot of people, family is not only an ideal kind of part of life, but a lot of people have issues with families running inside, and a lot of people don't want to work with family members because you might get into trouble with family members. Yeah, so it's like, it's more like a personal thing, probably. And sometimes working with someone who is like a professional are maybe better. So it's like maybe cultural thing, I think, Alexandra.
Okay. All right. I was thinking, the thing is, my culture was thinking close corporation. All right, guys. So this is the end of our corporate, our business entities. Next week, we're going to be talking about, and then I keep on saying next week, next couple of weeks, we're going to be talking about, corporate governance, partnerships, agency, etc. So how these structures are actually run. So I hope to see you in a couple of weeks. Thank you for your time and good evening.
Yes, everyone. Thank you. Thank you. Thank you. And what we are going to do also, so starting from this week, what we are going to do with you. So I'm going to post in our YouTube, not YouTube channel, in our Telegram and Contacte and so on. We're going to start revising the vocabulary from our 3 previous classes. So we will be trying to reflect back to the vocabulary, because half of our webinar series has passed. It's time for us to start reflecting on the vocabulary and to prepare us more for the future. So keep tuned, and we will be doing some exercises together and so on and so forth. So, and see you in 2 weeks, everyone. Thank you so much, Alexandra, and see you in 2 weeks. Bye-bye. Bye-bye, everyone. Bye.